pay advances are two different things depending on your perspective, but let's focus on what they are for purposes of the law and what we're talking about here. They would be providing money from the employer to the employee based on the anticipation of earning future wages. Employee says, I can't make my rent payment this month. Can you give me $500 and take it out of my pay next month or over the next 2 months, for example? The other type of scenario where something might be thought of as a pay advance but isn't going to qualify under the New York law and regulations is really what would more properly be characterized as a loan. Because if there is any interest or fee attached to the repayment, then for legal purposes here, it's not an advance and can't be recovered through wage deductions. Again, to clarify, this doesn't mean you can't give a loan to your employee. The owner of a business might have a friend or an employee working for him who, he wants to help out and even give, say, a $10,000 loan repayable over some period of time, and both agree that there's going to be interest or some other form of additional repayment beyond the amount that's given in the first place, the $10,000. That can be done. The company just can't take the money back through wage deductions, nor can it fire or discipline the employee for not paying the money back. If you want to have a promissory note or something like that and sue the employee if they don't repay, then that's not necessarily impermissible as long as it's done, otherwise legally. But again, you couldn't take it out of the wages. So what is allowable in the $10,000 case, even you could have an arrangement where the employee is going to get $10,000 and you're going to take the $10,000 out in, say, $10,000 installments if the employee makes enough money to cover that. But you couldn't say, here's $10,000 and we're going to take it out by $12,000 deductions, effectively returning $12,000 to the company when they only gave up $10,000 in the first place. Even if, based on interest rates and time value of money and that sort of thing, it would be reasonable to do that. You just cannot under the labor law. Okay, so where you can do this, again, we need an authorization. The employer and employee must agree in writing to the timing and duration of the repayment deductions before the advance is made. The employee, after signing that agreement, still has the right to revoke it up to the point when the advance is made. Now, they don't have the right to get the money and then say, I don't like this deal, but if they sign it and it's 3 weeks before it was going to be taken out of their pay, or even a week out of their pay, or theoretically even a day before it's going to be taken out of their pay, they could come back and say, no, I've changed my mind. I don't want to do this. It means they don't get the money. I just happened to see this quick question. Are the slides available in PDF? Yes, they will be at the end. We're almost done too, and you will get the link to that in a minute. So you don't have to feel like you need to copy all of this or take screenshots. And yes, there will be a replay video recording of this available as well sometime tomorrow. If you're registered for this, you will get that by email. Again, some of you have asked questions. If you have any questions, then go ahead and start typing those in, and I will stay on and answer all the questions after we wrap up. Sorry for that, but I just wanted to touch on those so those of you who are wondering the same thing have the answer. Okay, so we get to the situation where the employee wants to revoke, all right, we're just going to stop everything. It's not going to happen. But the authorization also has to include a notice that the employee can contest any deduction as not being in accordance with the authorization. So here, there hasn't been a revocation by the employee. The advance has been paid, and then the company starts deducting the money back from future pay. But the employee says, wait a second, you're taking more than you should, or you took it faster than you were supposed to, or whatever. There has to be a predetermined process to address that. Here are a few of the conditions around that. One thing that the law specifies, or the regulations make clear anyway, is that once you've entered into one of these arrangements with a particular employee, they cannot have another advance subject to these procedures. So you can only do this one at a time. So if you've agreed to advance someone $5,000 and it's going to be paid back over whatever schedule, until it's repaid in full, you can't then make another advance of any amount. The arrangement can provide for total reclamation in the last pay period in the case the employee is terminated from employment. So if, for example, you've given $6,000 and we're going to take $500 each out of the next 12 paychecks, but the employee only works through the next 10 paychecks, then the remaining 1,000, or really 1,500, because there's the one from that paycheck too, could potentially all be taken out of that final paycheck. On one hand, that assumes there's enough money in the final pay to do it, but it also, keep in mind, could include things like their payout of vacation or other types of benefit payouts. So often, or at least in some cases, that last paycheck is bigger than a regular paycheck. If you did have a severance arrangement or something like that, where you're offering the employee, for whatever reason, additional money that they weren't otherwise entitled to, you could likely also address that in that severance pay. Depending, I mean, if you have a existing severance pay policy, then that money might qualify as wage supplements, but in which case it would still be wages, and in which case you could probably still deduct the pay advance amount from it. But you'd have to look into those particular issues at the time. So finally, as I mentioned on the last slide, the employee can object to any deductions in writing. And once that happens, the employer has to stop the deductions until they reply with their position. So there's not quite as many specific limitations and procedural requirements as there are for overpayments, because you've already agreed to this up front before even giving the money, unlike the overpayment where the employee just got the money and is good to go. So you could put whatever procedure you need in to satisfy both the employee and the company, as long as there's the allowance that once the employee says, I don't think you should be making these deductions, the company has to stop until they at least reply with their position, which case they can go on making the deductions, subject to the employee going to the Department of Labor or hiring an attorney or whatever and saying, wait, we don't think you should do this.